Thank you, everyone, for joining us. As Ben said, good afternoon or good evening or good morning, depending on where you're at. We want to welcome you to this discussion on the updated commentaries to the Third Geneva Convention. Again, my name is Michael Meyer. I am the Special Assistant to the Army Judge Advocate General, which is Lieutenant General Chuck Peedy, for Law of War Matters, and I serve as the Vice Chair of the Lieber Society of ACIL. Over the past 70 years, the Third Geneva Convention has ensured that the prisoners of war are treated humanely and with respect for their dignity while in the hands of enemy forces, saving countless lives. This convention was drafted in the wake of the Second World War, during which time millions of prisoners of war were victims of horrific atrocities. And the convention revised and expanded the existing protections afforded prisoners of war under the 1929 Convention. The 1949 Convention contains 143 articles, 46 more than the 1929 Convention, and the additions and revisions were necessary given the changes that occurred over the 2 decades in the conduct of warfare and its consequences. Since June of 2020, as part of the ICRC's multi-year effort, the ICR launched the updated commentary to the Third Geneva Convention of 1949, which follows their updated commentary to the First Geneva Convention in 2016 and their second one in 2017. And this updated convention analyzes how practices in the application and interpretation of the 4 Geneva Conventions have evolved over the past decades. And it provides fresh interpretations of the convention and takes into consideration legal and technological developments that have occurred since the commentary was published over 60 years ago. And today I'm pleased that we have 3 distinguished panelists with us to discuss the updated commentary to the Third Geneva Convention. First, we have Cordula Droga, who is the Chief Legal Officer and the head of the legal division at the ICRC in Geneva, where she heads the ICRC's efforts to uphold, implement, and develop international humanitarian law. She joined the ICRC in 2005 and has held a number of positions in the field and at headquarters, including as head of the legal advisors to operations, and most recently as Chief of Staff to the President of the ICRC. Next, we have Tess Bridgman, who is the co-editor-in-chief at Just Security. She's also a senior fellow and visiting scholar at the Rice Center on Law and Security at NYU School of Law. She most recently served as Special Assistant to the President, Associate Counsel to the President, and Deputy Legal Advisor to the National Security Council during the Obama administration. She also previously served at the Department of State in the Office of the Legal Advisor, which is where I got to meet her, and we became friends. And we look forward to having her. And then finally, certainly last and not least, is Sean Watts, who is a professor in the Department of Law at the United States Military Academy at West Point, where he co-directs the Lieber Institute for Law of Land Warfare. He also serves as the co-editor of the new Law of War blog, Articles of War. So please check that out. Sean is also a contributor to the updated commentaries to the Third Geneva Convention, so we look forward to hearing his comments on that. For those of you that haven't done this, and I think that would be very rare, as you know, we certainly want to hear from you, and we request that you submit your questions in the Q&A box, and I will intersperse those to the panelists when they speak. So Cordula, I want to start with you. One of the first questions that came to mind when I heard about the commentary, and what I hear other times, is why? What's wrong with the Pictet commentaries from '54? So what led the ICRC to begin this project? And I'd also, I'm sure our audience would like to hear how the process has worked. We mentioned Sean as a contributor. So how did you kind of pull all these disparate voices and opinions together into a coherent project of the commentaries? So over to you.
Thanks a lot, Mike, and thanks for inviting me. Can you hear me well? Great. I also hope you can only hear me. I just wrote a little SMS to my husband telling him that my son should be less loud. So I hope it'll only be me and not much background noise. And so, yes, there's nothing wrong with the Pictet commentaries, and you should all continue reading it, in fact. The thing about the Pictet commentary, though, is they date from the 1950s. They were mainly based on the preparatory work and prior practice, and in particular the practice of the Second World War. And so about 10 years ago, 6 years after their publication, we found that they had become incomplete. and in parts also perhaps outdated. And as a practitioner, when you looked for guidance in your work, you would still often find very useful information, but some of the questions would just simply not be addressed because they could not anticipate, of course, all the detail in the 1950s. And of course, there's also a lot of subsequent developments that could not be taken into account. And so as the guardian and promoter of IHL, we needed to ensure that the commentaries to the Geneva Conventions remain up to date so that they continue to be used and to be useful. These are commentaries that are meant to be a tool mainly for practitioners, including government lawyers, armed forces, judges, academics. And so to have easy access, in one place to up-to-date interpretations of the Geneva Convention. So that's how we decided to embark upon this quite mammoth project, I have to say. And then, Mike, you asked about how are we going about it? How are they being updated? What's the process? So it's actually quite simple because we follow the methodology of treaty interpretation set out in the Vienna Convention on the Law of Treaties, so Articles 31 to 31 and 32. So as a result, what we do is, first of all, of course, take into account the good faith interpretation, the ordinary meaning of the terms in their context, and the object and purpose of the convention. And in addition to that, and that's, I think, very important, is the subsequent practice in the interpretation application of the conventions. And we can perhaps, if you want, discuss a bit further about that in the questions and answers. And also important, and you will see that reflected, also other relevant rules of international law. And then, of course, you have the subsidiary means, the preparatory work. And although the Pictet commentary already relied a lot on the preparatory work, we still went back to that as well. And you will see in each of the sections, you will often have something about the 1929 convention, even what happened before. So a little historical background as well about where the commentaries, where the articles came about. Now, the other thing that methodologically I think was interesting and that really differed from the first commentaries of the 50s and 60s is that they involved a really unprecedented level of outside involvement. So we have external contributors, writers, to some of the commentaries, so not just ICRC lawyers. We have a diverse editorial committee, which includes also external members to the ICRC. And most importantly, we have a peer review group of about 50 experts, both practitioners and academics from around the world, because of course, IHL is a universal body of law, who in their personal capacity review the drafts and provide feedback. And so this has ensured that we get these diverse views taken into account at all times. And so as a result, I think what we have are three important characteristics that perhaps set this updated commentaries apart from the initial commentaries. First of all, the updated commentaries not only review the preparatory work, but they also take into account subsequent practice, subsequent developments in international law that have taken place over 70 years, and the importance of this as recognized in Article 31 of the Geneva Convention. And then secondly, as I mentioned already, there's a real difference in that the commentaries aren't only drafted by ICRC lawyers, so 4 or 5 ICRC lawyers, but also by external experts and reviewed by external experts. Including experts from the US and Canada, and we have an eminent expert, of course, on this panel. And then what that means is that the updated commentaries, unlike the Pictet commentaries, don't only reflect ICRC interpretations where they exist, but they also reflect main diverging views. And this is something where we learned a lot from external authors, but also from the peer review process, which allowed us to know about diverging views when we perhaps weren't so attuned to them, to perhaps also mention additional sources which we might not have known, etc. So it was a very useful process, which I think is then reflected in the text and the different views that we try to reflect in this commentary, while of course the commentary remaining an ICRC product. And perhaps just to finish off, just some examples, Mike, on how this manifests itself in the new commentaries. So in terms of the update, I think, and being more, in line with contemporary understandings and subsequent developments, you will see, for instance, that there's of course a lot about the health and medical care for POWs in the Third Geneva Convention. It's one of the really important parts of the convention. And in this case, we really took into account more the reflection about the importance of mental health aspects and not only physical health. This is actually something that's already in the conventions and in the text of the convention. When you look, for instance, at Article 17, which mentions physical and mental torture, Articles 49, Articles 110 about the physical and mental health of prisoners of war, but I think it was perhaps not as well understood 70 years ago as it would be now. And it is an enormous part, of course, of the health of people who are detained, particularly if they're detained over a long period of time, with little connection to their families, etc. In a similar way, I think this commentary also reflects a contemporary understanding of disability. Again, disability in that sense is something that's reflected already in the 49 text, and the convention was, in its own way, quite progressive about this. But if the social understanding, perhaps, or the understanding of disability was more about disability requiring medical treatment, and it wasn't so much an understanding that disability creates social barriers, and that there's a need for social inclusion in disability. And so this is also something that we try to reflect in the commentaries, for instance, in the rules on adverse distinction. And more broadly, it deals with a range of medical issues such as isolation, prevention of epidemics, taking into account really contemporary standards of medical ethics and medical confidentiality as well, that were not so much highlighted in the 49 or in the 50s commentaries, sorry. It also reflects, for instance, current rules on privacy and data protections, which is quite a difficult question, actually, because prisoners' data is, of course, personal data, and is collected and shared through various channels, the National Information Bureaus, the CTA, and the assumption, of course, of GC3 is that this is a good thing and that this data should be shared. But of course, today's understanding about, informed consent and these kinds of things have to also be taken into account when thinking about this collection of data. It also takes into account, and this is important, and we can perhaps come back also on that in the Q&A if participants are interested, the different needs of prisoners based on age, sex, health. So it really applies a gender perspective throughout the convention, and not just with respect to the articles that specifically refer to women. And perhaps lastly, it takes into account developments in technology. So for instance, just a very simple example would be, about the contacts of prisoners with families and with the ICRC, where it's not just about faxes and letters, but of course it can also be emails, teleconferences, video conferences. And these are things that exist today for detainees. So that was just to give some examples. And then perhaps just to conclude, it seems to me to be important to highlight that the Geneva Conventions are a strong and detailed and precise body of law that govern international armed conflicts. You were mentioning, Mike, it has 143 articles in GC3 alone. And I think they withstood the test of time because they remain relevant today and sadly in a way, but my colleagues at the moment who are working on the conflict in Nagorno-Karabakh, of course, have resort to the commentaries, to these updated commentaries. But their enduring relevance also depends on their interpretation. And we have to interpret the Geneva Conventions as a living instrument, as an instrument that has to be in line of contemporary armed conflicts, relevant in contemporary armed conflicts, and therefore grounded in contemporary international law and the realities on the ground of armed conflicts today. Thank you.
Great, thank you very much, Cordula. That was a great overview of commentaries and the sort of the different changes, and I appreciate the fact that you've addressed sort of some of the aspects of the changing laws, sort of the Convention on persons with disabilities, and then how you've tried to weave that in there. I guess one question, and certainly this is the point where I would encourage our participants to please use the Q&A and ask the questions that you would like to hear as well. You've talked about how you've brought some of those other aspects into this commentaries. How did you sort of work that, when you're really dealing with states that, such as the United States, we're not necessarily a party to some of the different treaties and conventions that are referenced in the commentaries. How did you try to work those to sort of maintain, I guess, the balance, and what would be the one overarching piece you would like practitioners to take away from the change?
Subsequent practice is actually dogmatically quite a complicated thing, because of course, if you look at Article 31 of the Vienna Convention on the Law of Treaties, it talks about subsequent practice that reflects a common understanding between the parties to the conflict. So traditionally, it would be all the parties between the parties to the treaty. So traditionally, you would understand this as being all the parties to the treaties. Now, with the universal text like the Geneva Conventions, you won't find all the time unanimous practice, of course, that isn't diverging. And so it seemed to us that what was the most important is to take into account subsequent developments in international law, because the treaties are not, they can't live in splendid isolation. And of course, there is a presumption in international law that parties to a treaty intend the treaty to be to not be in contradiction to other obligations that they have under international law. And so in particular, of course, obligations under international criminal law, international human rights law, international refugee law, maritime law in particular, that was relevant for the second Geneva Convention, should be presumed to be the Geneva Convention should be presumed to be interpreted in a way that is compatible with these other bodies of law. And as you said, of course, other bodies of law are sometimes less universal than the Geneva Conventions, and different states are party to different treaties, but some treaties are fairly universally ratified, such as, for instance, ICCPR would be one. And so we did try to take into account national practice, particularly, of course, military manuals, military doctrine, in a sort of comparative law approach, and also the jurisprudence of some of the bodies, international bodies that interpret other notions of international law that are similar or even the same as those in the Geneva Convention. So, for instance, the concept of torture or ill treatment. And it seemed to us that you don't need to then, when you're a practitioner for your own country, you don't need to, of course, take into account all of the sources that are mentioned, but you will take into account the sources that are relevant for your context, for your state, for your armed forces, and so forth. But sometimes a comparative law approach or subsequent practice can also be informative, not only about the outcome of, for instance, a decision, but also about the argumentation about why a certain concept should be interpreted in a certain way. And so what we're hoping with this commentary, which has extensive sources, of course, and long footnotes, is to give as comprehensive an overview as we manage to explain concepts and interpretations that exist in the Geneva Conventions.
Great, thank you very much. And since we have our other two panelists, I want to certainly move over to Tess at this point. Tess, since this is the third Geneva Convention relative to the treatment of prisoners of war, an important piece of that is who is actually going to be covered. Article 4 addresses, who's entitled to POW status. Could you talk a little bit about Article 4 and how you see that playing out now with sort of conflicts that we're running across today and different things. Over to you, Tess.
Absolutely, Mike, and thank you for that wonderful overview. I'm of course going to delve into a much narrower topic, but everything that was just said is really helpful context for it. And Article 4, as you just mentioned, Mike, it is, as the Pictet commentary put it, the key to the convention, since it defines who is entitled to be treated as a POW. It's the gateway to all of the protections that we've just been discussing, underpinned, in fact, even by a criminal enforcement regime, right? The mistreatment of persons entitled to POW status can constitute a grave breach of IHL, all of course applicable in international armed conflict, or IAC. And as was just mentioned, IACs have become a lot less frequent. They're certainly not gone. And with the frequency of NIACs, governments have over the last several decades started to move to attempt to apply certain IAC principles in the NIAC context for various reasons that are described as providing certainty of understanding, sometimes described as gap filling, sometimes described as simply providing interpretive guidance for principles that are laid out in a higher level of generality in law directly applicable to NIAC. And I recall sitting down the hall from Mike in 2009 in the Office of the Legal Advisor at the State Department, shortly after the United States had committed, in the context of the Guantanamo habeas litigation, to attempts to apply, in essence, by analogy, certain IAC principles to the detention operations at Guantanamo, and in particular to determinations as to who is detainable. And this is something that caused us to spend weeks and months going through history, the travaux, the conventions and regulations and declarations from which the Third Convention evolved, the manuals of other states, as well as our own historical law of war manuals, the subsidiary means that were just referenced in terms of relevant writings of academics. And now this is all in one place. And so I am grateful to the ICRC and all of the contributors for undertaking this project. If we had had this at our fingertips in 2009, our nights would have been shorter and our days more productive. So I just want to commend you for undertaking this effort, because indeed, all of those pieces are brought to bear in the 2020 commentary, and with respect to Article 4, you really see them all providing a lot of clarity and a crispness of interpretation that's really helpful. I find particularly helpful that the ICRC chose to try to take a position on some of the debated topics, and I'll get to that in a second. One important side note, of course, is that while there are, of course, great stakes in terms of who does and does not qualify for POW status, there are, of course, numerous protections in IHL for those who do not so qualify. So I think it's also important to keep in mind that while the while the Third Convention stems from an era that was on the heels of a time when not qualifying as a POW could in fact result in summary execution. That's of course no longer the case and hasn't been the case for quite some time. So it's just important also to keep that context in mind, that a failure to qualify as a POW doesn't necessarily have the same stakes in terms of the protection gap as it may have in earlier eras. So a very brief refresher on the structure of Article 4, since it is a bit complex. It of course first lays out that prisoners of war are persons belonging to any one of 6 categories when they have fallen into the power of the enemy, which the updated commentary makes clear is the same as the power of the enemy and the hands of the enemy are the same thing. That's state armed forces and regularized militias, formally incorporated. Irregular militias that nevertheless belong to a party and meet 4 conditions that we'll get to in a second. Civilians who accompany the armed forces without actually being members thereof, so long as they are authorized to do so. members of the Merchant Marine and Civil Air Crews, and the levée en masse, which I will leave to one side for now as well. It also then extends the protections of the convention to past and present members of armed forces who've been re-interned in occupied territory or have been received by a non-belligerent party, and then has a savings clause, just bearing in mind that the article in no way affects the status of medical personnel or chaplains. So I'll just focus on a couple of provisions with practical utility that I found of interest in the updated commentary, and we'll unfortunately have to leave aside a great number of those categories for now, since it is so detailed and there is so much there. What I'll just touch on briefly is the issue of when irregular forces should qualify for POW status. What regularizes them sufficiently is one way to think about it. When do members of regular armed forces lose the protections of POW status? And then with the huge growth of civilian contractors, how we should think about the Section 4A4 accompaniers who are in that narrow and somewhat odd category of civilians who are nevertheless entitled to POW status if they fall into the hands of the enemy. So the first of those, when should irregular forces qualify for POW status, is something where I thought the 2020 commentary just does a tremendous job of offering really concrete guidance. The breakdown of two requirements, right, belonging to a party and then satisfying the four conditions is laid out much more clearly. And there's quite detailed guidance on what it means to belong to a party, which is something that we paid a lot of attention to in recent armed conflicts that the United States has been a party to. The group must in fact fight on behalf of the party, and the party must accept both the fighting role of the group and the fact that the fighting is done on its behalf. That's a really helpful test to have laid out that clearly. I imagine states may have somewhat different views on the contours of that test, but I think it's a really helpful and crisp articulation of that important point. But it also goes one step further. What does it mean for the party to accept the role of the group who is doing the fighting on its behalf? The commentary goes on to specify that acceptance can be express or a tacit acceptance of a de facto relationship, and then demonstrate several ways that can be met by contracting with a group of civilians to perform a combat role, even by failure to deny a relationship when asked in a public context, or by a demonstration of overall control, right? So if a party to a conflict has overall control of the militia with the fighting function that's operating on the state's behalf, then that belonging to criterion is satisfied for 4A2 purposes. So I found that really crisp articulation very helpful. Now, when states disagree on these topics, this gives a much more, I think, crisp and concrete starting point from which to have those discussions. There's also a lot of practical guidance on the four conditions then that irregular forces would have to meet. The being commanded by a person responsible for subordinates, having a fixed distinctive sign, carrying arms openly, and conducting operations in accordance with the laws and customs of war. In each of these, there are several criteria mentioned, and what I found the most useful is there's often a touchstone, right? So rather than trying to rigidly prescribe the very specific contours of what these provisions must mean, there is guidance offered, and then a sort of at a more general level, a touchstone to look for. So for the responsible command requirement, for instance, the command structure need not be sophisticated, it need not be rigid, and then in my reading, the touchstone that was offered is the importance that commanders are in a position to ensure internal discipline and encourage IHL compliance. Or in the next section, the having a fixed distinctive sign recognizable at a distance. there's a lot of specificity that you could get into there, but the touchstone that's offered is wearing a uniform, right? That's the simplest way of satisfying this requirement, and that's a helpful thing to look for. The one place where I thought there was some interesting daylight between PICTE and the 2020 commentary was that of the requirement of carrying arms openly, which seemed in my reading to have a somewhat different import in each of the two commentaries. The PICTE version seemed to suggest that it is not a requirement, right, that a hand grenade or revolver must be carried at belt or should rather be in a pocket or under a coat. Whereas the 2020 commentary says, while the condition would be met by use of the holster, it would not if weapons were hidden on the approach of the enemy. I'd be interested in the views of my co-panelists, in fact, on whether there is in fact some daylight there, or whether that's whether there's another way to read that. So I'll stop there on the irregular forces question in the interest of time and touch briefly on when members of armed forces lose their protections of the Third Convention, because it isn't in the text at all. This is a really interesting topic for the commentary to pick up. And not only is this new to the 2020 commentary, but again, it's quite concrete. So the kind of categories of issues that are taken up are the obligation for regular forces to distinguish themselves from civilians, the issue of engaging in espionage or sabotage, what to do with deserters and defectors, and the status of mercenaries, and none of these are really addressed, or certainly not in any great detail or with much clarity in the earlier PICTE commentary. So I thought it was quite helpful to see all of those laid out here. I won't go through now. I'm happy to in the Q&A, if that's a topic of interest, talk through how it is that each of those are addressed with respect to regular forces losing their protection. But suffice to say, I think the same sort of principle that I was just mentioning with respect to irregular forces, and here as well, where there is some specific guidance offered, but then and relevant customary international law is brought to bear to contextualize the principle at issue. But then there's also a touchstone offered for flexibility of interpretation and ensuring that the convention remains a living framework, as was just mentioned. And then finally, one last issue that I'll touch on is the question of what should we think about the Section 4A4 category of accompaniers, those who accompany the armed forces without being members thereof. This is that pesky category of civilians, nevertheless entitled to POW status when they fall into the hands of the enemy. And with the growth of the use of contractors and in increasingly, I think, technical and really proximate positions to the fighting, this is of course a matter of huge interest. The PICTE commentary had almost no guidance on this particular provision, so I was glad to see it taken up here. We see a bit of a discussion of the types of accompaniers who we're actually talking about in 2020 parlance, right? So those responsible for laundry and transportation and food and waste removal, those are very sort of specific and nitty-gritty categories. But then kind of an important and a more difficult one is the contractors that are used for things like maintenance and operation of technologically advanced equipment or vehicles. There's, of course, the issue of war correspondents being covered here, but not other journalists, not those who are so authorized by the armed force to accompany them. And then there's discussion of private military and security companies, PMSCs, with use of the Montreux document from 2008 to provide additional context to who we're talking about there. And here's where the one place where I actually would have liked to see a bit more is the question of what specific functions could take an accompanier, particularly a private military or security company personnel or contractor, out of that category of retaining their civilian status and and make them cross the line into committing a belligerent act or directly participating in hostilities. And I will, of course, recognize that that's not necessarily a question for the Third Convention that gets into issues of what constitutes the conduct of hostilities. It's something that, of course, we would probably see Article 5 tribunals convened to try to address. And the commentary does state, of course, that as a matter of logic, they are civilians, but they do not then have the right, of course, to participate directly in hostilities with immunity from prosecution for such acts. I think what will then be the next step is for states to cross-reference this with the ICRC DPH study and their own views of what constitutes direct participation in hostilities. But this is an issue where I think states still have some fairly divergent views, and it would be interesting to see the ICRC, as they did in several of the other important provisions here, take a position on where those lines are. So, Mike, I think I've taken my allotted time and then some. This is obviously a really rich article with a lot of guidance, drawing from a huge body of practice that does not gloss over disagreements and for the most part tries to take a position on some of those difficult disagreements that it identifies. So, again, I commend the ICRC and the contributors for putting this together in such a clear and comprehensive fashion. And I'll leave it there for now.
Great. Thank you so much, Tess. And you raised a lot of great points. And this is normally where I'd ask you a question, but in the interest of making sure Sean has sufficient time, if it's okay with you, I'm going to go straight to Sean. And Sean, we appreciate you waiting for us. You bring the sort of unique perspective that you're not only now a well-respected academic, but we served together in the Army JAG Corps, so you have a practitioner's perspective as well. So I guess what do you see with respect to the utility that this new commentary brings? And Tess has raised some great points with respect to Article 4, for sort of from an academic perspective as well as your practitioner hat. I would like to hear your thoughts on the new commentary.
Okay, well, thank you, Mike, and thanks to the other panelists as well for some terrific thoughts on this. As Mike said, I've just rejoined government service back in August, and so that means I have to offer my disclaimer, which is that these are my personal views on the commentary, and they don't reflect necessarily the views of West Point, the Department of the Army, or the Department of Defense. So I'm not authorized to say what any of those agencies think of these commentaries, although I think it's critical that they voice an opinion on them. But what I am authorized to do, I think, is to congratulate the ICRC, particularly Jean-Marie and his editorial team on producing an awfully impressive product, I have to say. This really is worthy of quite serious attention. In that respect, at the Lieber Institute at West Point, we intend to give it exactly that. I'm very happy to announce that we have planned for next semester a semester-long study dedicated exclusively to the updated commentary. I'll be leading 10 cadets through a critical examination of the updated commentary. The text will be the commentary itself. And so it's our plan very much to evaluate it and to look at it from the perspective that Mike suggested here. How helpful is this to practitioners? How useful is it? How helpful, how practical is it for scholars as well? So we're hoping to make some evaluations in that respect, and then also to publish and compile some annotations. We won't call it a commentary on the commentaries. We'll come up with something more clever than that, hopefully. But that's very much our hope. And again, this will be an academic product. It won't be the views of the United States government, but we're quite excited about it. And this is such a monumental work that it certainly deserves that kind of attention. In these opening remarks, I'd like to offer a few preliminary thoughts. I'll reserve my final conclusions perhaps for next spring. We've had a chance to really digest this thing fully and to take into account what will be, I'm sure, some helpful insights from the cadets themselves. But preliminarily, here are just a few thoughts. First, on its utility to academics, and then secondly, its anticipated utility to practitioners. With respect to academics, gosh, I don't know that there's a better single source for understanding what's being said out there in academia about this subject, about prisoners of war. were I a brand new scholar, this might be my first stop. It really is a helpful compilation of scholarship and academic views. There are cutting edge views, there are well-established views. If I were just getting started here, boy, this is where I might begin. I think it's also a helpful starting point to understand the history. Each of the articles has a very helpful section that explains the development of that article, some of the negotiating history. So there is legal history there, but more importantly, and what I found more attractive in the sections that I've looked at very carefully, is some of the military history that's included as well. There are practices of states, practices of detaining powers that are featured quite extensively in the commentary. And so for that reason, I think it's an especially interesting tool for academics and new academics especially. Now, it's just a starting point, right? You would want to examine, of course, the negotiating histories yourself. You would want to examine the primary sources for both the legal developments and the military historical developments that I mentioned. But boy, what a terrific starting point. Last, with respect to the utility of the commentary for academics, I'll say it presents innumerable opportunities to think about interpretive method. By this, I mean, I think it's unmatched as a tool for considering how to read the law of war. Cordula very clearly and patiently explained some of the methodological choices the editors made in producing the commentary. And on this point, it's just invaluable to academics. The more time I spend in our field, the more I realize that if we disagree about the content of the law, as academics, more often we're actually disagreeing about how to read the law. There are deeper disconnects going on within the law of war community. And this product, this updated commentary, is an excellent illustration of so many very different interpretive approaches. Cordula pointed out, and the convention, or rather the commentary itself declares in the introductory section, that the convention is a living instrument. And this is its entree to invite in subsequent practice. That is these 70 years of practice that Mike mentioned in his lead into the panel, that the intention of the updated commentary is to account for that subsequent practice. But this declaration of it being a living instrument, or this intent to account for subsequent practice, it's a bit misleading. I think it's misleading in two respects. First, I think it undersells what's actually going on in the commentary. Classically, by subsequent practice, we mean the Article 31 description of the Vienna Convention on the Law of Treaties that Cordula shared with us. And she was quite frank that there are frankly different views on what that means. I think classically state practice under the Vienna Convention, Article 31, has meant, well, the subsequent practice of states. What have states done? And there's a further refinement in Article 1 that says, well, look, and not just all state practice, but that state practice that is clear evidence of agreement. That is, that the parties, having the advantage of time and experience and state practice, can all agree. And I would say agree to the same extent that they agreed in the formation of the treaty in question, all agree that this reflects a new standard of law. If that's what's classically meant by state practice under Article 31, that's not quite what we're seeing in the updated commentary. I think we're seeing a more relaxed notion of it. First, when we refer to this subsequent practice, we're not referring, I think, in all cases, to that state practice that is evidence of the very high level of agreement that Article 31 would classically require. And then secondly, there's just some citations in the commentary to subsequent practice. It's not state practice. It's the practice of private organizations. It's the practices and views of academics. So in that respect, this promise to, or this dedication to subsequent practice requires an adjustment. And it may be justified, it may be valid, it may be invalid, it may have compromised the validity of the commentary, but this is what's so exciting about it from an academic viewpoint. This is really rich, fertile territory for scholarship on exactly these kinds of questions. The second respect in which I think this promise of the convention, or this evaluation of the convention being a living instrument, is that, well, you might expect a very consistent interpretive approach then that you would expect throughout. This is going to be the kind of analysis that would always regard it in that respect as living and breathing and changing, evolving. In truth, the commentary doesn't offer anything like a consistent interpretive method. For some, it will disappoint in this respect. For others, it will not. It is an enormously diverse collection of interpretations here. And that's why I regard it, again, to be so useful to academics. I'm extraordinarily excited about using the commentary to expose our cadets to all these various methods of interpretation. In the interest of time, I'll get to them here, and maybe we'll have some time for more specific examples. But for just a few illustrations, it swings sometimes between this dogmatic formalism. There are very much comments that refuse to budge from the very literal meaning of the articles. On the other hand, there are quite open-ended functionalist articles as well that feel perfectly content and are very comfortable breathing new life or even new meaning, even to the point of, in some cases, amending the articles. So there's a contrast in interpretive approaches with respect to formalism and functionalism. I think it features also contrasting approaches to negotiating history. In some cases, there's an extraordinarily faithful adherence to what the travaux preparatoires suggest about the intended meaning of provisions. But just as easily, there are sections that outright reject the preparatory work that went into the conventions. There are, I think, classic applications of general international legal doctrines. I'm thinking of lex specialis. There's a quite, I think, classic conventional application of lex specialis with respect to the obligations under Article 5 to convene competent tribunals to determine the status of POWs. But on the other hand, there's a quite revolutionary use of lex specialis, which invites in human rights standards to understand how to use weapons against prisoners of war in an internment context. There's similarly, I think, with respect to understanding religious duties, the sort of reverse flow lex specialis. That is, we're reaching outside the law of war to understand the meaning of a law of war provision by resort to a human rights standard. So again, really, I think, fascinating opportunity for academic exploration there. There is a fascinating, I think, but in some cases troubling resort to principles. There's a quite extensive list of principles. They aren't listed for you all in one place. I've actually had to keep a running tally of all the places in which the updated commentary identifies either a principle of law, a principle of international law, a principle of the law of war, or a principle of the convention. There are even principles of the convention itself. And these are put to, in some cases, I think, helpful use, but in other cases, somewhat troubling use. I'll mention the principle of assimilation as one that I find a bit troubling, the way it features in the commentary. So there's lots more, but in the interest of time, I'll just say this. The updated commentary is extraordinarily complex in its interpretive approach. It's an extraordinarily useful tool. It is complex, I think, from an interpretive standpoint to the point of being almost enigmatic. But again, that's where all the fun lies. I think this is why it has such enormous scholarly potential. Turning quickly to practitioners now. So how useful is this to practitioners? And by practitioners, I'll mean states' legal advisors. There are no doubt practitioners in non-governmental organizations, in international organizations that will resort to the updated commentary. But I have in mind legal advisors to states. I have in mind lawyers like Mike Meyer here, or lawyers like my colleagues in the JAG Corps. How helpful can such an academically interesting product be to very practically minded state and military lawyers? On a positive note, I'll say that it is extraordinarily well timed. States' defense policies are increasingly turning attention to peer-to-peer, or what some call great power conflict. So in this respect, guidance on the treatment of prisoners of war in international armed conflict is extraordinarily well timed. So, they always say it's better to be lucky than good. I think the updated commentary is extraordinarily fortunate in its timing, that it offers this guidance at a time when I think states really very seriously are going to have to turn their attention more seriously toward prisoners of war and toward the types of detention operations that feature in these peer-to-peer and great power conflicts. So well done there. It's also, on a positive note, I think, packed with very helpful cross-references. The conventions are imposing themselves. We've got 143 articles in the third convention. I remember as a new lawyer being overwhelmed by the convention, frankly, and being overwhelmed, even more overwhelmed by the fourth convention, which runs, I believe, 159 articles. So navigating that convention can be extraordinarily challenging, and the updated commentary has extraordinarily helpful cross-references, not simply within the articles of the conventions respectively, but between conventions as well. You'll find very helpful references in this updated commentary to the third convention on how those provisions might relate to the first convention as well. For the additional Protocol 1 states out there, there are some references to additional Protocol 1 provisions that are going to be very helpful, I think, to practitioners as well. Last positive note, I don't know, Space Force, US Space Force, if you're out there watching us, good news, you get a mention in the updated commentary. The updated commentary is perfectly clear. No POW camps allowed in space. You're going to have to get those prisoners that you capture up in space back down to Earth, because the commentary is quite clear. You cannot intern them out there in space. So even something for the Space Force practitioners out there. Okay, on a cautionary note, there's this. This is not your grandparents' commentary. This is not Pictet's commentary. This is a vastly different commentary. And it's chiefly with respect to some of the interpretive approaches that I outlined previously. It is, I think, it strikes me as a decidedly academic work, both in its sourcing and in its interpretation. My advice to lawyers and to practitioners is this: apply it at risk, be very careful with it. I think the first step for any practitioner that seeks to use the updated commentaries, she's got to consult her national military legal doctrine. There are, and I think in some cases, the commentary is quite good at laying its cards on the table and saying, I'm sorry, we just disagree with the United States on whether, for instance, to circle back to Tessa's comments, whether the 4A2 conditions apply to 4A1 armed forces. The commentary, I think correctly, frankly, again, these are my personal views, says those 4 conditions are inapplicable to members of armed forces. That's not the view of, for instance, the United States government and some other governments. So you really have a duty, I think, as a practitioner, to check in with your own national military legal doctrine. And I know the ICRC would not contest that. My last point is this: I'd say keep reading. Once you've read your national military legal doctrine, do check in with the updated commentary. It will provide you not only the cross-references I've mentioned before, but also some insight into other views you will encounter on the battlefield, either from non-governmental organizations who are involved in the work of enforcing the convention, but also the views of some of your allies. Even keep reading within the updated commentary. It's a big ask. I don't know what the pagination is going to be. The second updated commentary addresses, of course, the second convention, which has in the neighborhood of 60 articles. That commentary runs to 1,300 pages. We've got 143 articles in the third convention. I can only imagine the pagination must be lapping at the banks of 2,000 pages here. So all that admitted, I say you've got to keep reading this thing for 2 reasons. First, there are some conflicting obligations, frankly. There is some guidance that points in different directions within the updated commentary. I'll mention the commentaries on Article 23 and 48 as offering conflicting guidance with respect to an obligation to reveal the GPS coordinates of a POW camp. A practitioner looking at this simply wouldn't know which way to go. Secondly, keep reading, because there's a slightly annoying practice in the updated commentary. A couple of the comments actually lead in with quite unequivocal language as to an obligation. And so you'll read and you read 2 paragraphs, 3 paragraphs, and you read, my gosh, really? There's no concession to military necessity here, only to find maybe 5 paragraphs later, well, okay, in cases of imperative military necessity, the obligation is relaxed. It would have been nice to hear that at the beginning before, 5 paragraphs of me stressing out saying, oh my God, what have they done with this article? So keep reading. Don't quit on an article. Don't read the first 2 paragraphs and think you've got it and move on. So some practical tips there. Ultimately, here's my advice. States have got to respond to this thing. They really do. It's imperative not only that to augment the thing's utility for their practitioners, states have just got to make clear, they've got to participate in this conversation. They've got to make clear their sense of state practice, their sense of opinio juris. I think they should even weigh in on the methodological and interpretive points that I outlined in the first. So, Mike, I'm sure that's exactly what you do every day there in the Pentagon, right?
Exactly. So, in my copious free time.
Yeah.
Thanks, Sean. That's really great. And unfortunately, we're running up against the 1 o'clock cutoff time. So what I want to do, and I apologize to both you and Tess, is I'm going to swing back to Cordula, give you guys each a chance to make a sort of quick remarks on what you heard from each other, and then a closing statement if you have it. So, but just very shortly, because we're at 12:59. Just if you want to try to quickly respond, let's try that. Over to you, Cordula.
Thanks a lot. So very quickly, thank you very much, Tess, for your kind words about the way we try to tackle the complex issues in Article 4. Perhaps the one thing, I don't think there was an intended difference about carrying arms openly. And I think on the reconciling of who remains a civilian, who is a civilian, who is DPHing, I think we would rely on our differentiation between continuous combat function and civilians DPHing. But of course, as you said before, not everyone agrees with that, and that's well understood. And then on methodology and interpretation and so on, perhaps just thanks to Sean for sort of unpacking many of those issues. And indeed, I think Sean is right. We rely, I think, more coherently than perhaps Sean was thinking, on a variety of interpretation tools which are foreseen in the Vienna Convention on the Law of Treaties. But of course, interpretation in itself is a whole science. And what we found very helpful, for instance, would be to also read the works of the International Law Commission about fragmentation of international law and how different concepts such as lex posteria, lex specialis, norm conflicts, etc., could be dealt with. And so perhaps for people who want to understand a bit better how we try to explain our methodology, we do so quite extensively in the introduction, but also the introduction to the first and second Geneva Convention. So it's not necessarily all repeated in the third Geneva Convention. So not only is the third Geneva Convention going to be about 2,000 pages long, but on top of it, you have to read the introductions to the other Geneva Conventions. So it is indeed, it is a monumental work, but I think it is worth doing that in order to be as comprehensive and also as intellectually honest as possible, and that's certainly what we've tried to do. And then perhaps also to say in terms of subsequent practice, and I think the question of state practice is really one that is, that is foremost, of course, in the minds of states. And there I would say it is true that, Article 31, as I said before, and I think as Sean also mentioned, is a very narrow Article 31.3c is a very narrow concept of subsequent practice. But again, when you look, for instance, at how the International Law Commission sees it, it also talks about subsequent practice in Article 32, and that is subsequent practice that doesn't necessarily reflect a unanimous understanding by the parties to a treaty about its interpretation. But of course, each state is also subject to the Geneva Conventions and a variety of other international obligations. Of course, the first one coming to mind is some are party to AP1 and some are not. And of course, that makes a big difference in how you then also interpret the Geneva Conventions. And so we also made very clear in the introduction that, of course, when we mention other treaties, these, of course, only bind those states that are parties to those treaties. I think I'll leave it at that. Thank you.
Thank you, Cordula. Tess, any closing thoughts?
I'll be incredibly brief, just to say that I look forward to reading the views of states that Sean has called for states to offer up. I think it will be some time in coming, given the length and complexity of the issues addressed here, as as evidenced by the session that we've just had. But I completely agree on the imperative of states to respond and to engage with this useful new resource. The last thing I'll say is, Sean, I look forward to reading what you and your students produce, comparing your grandparents' commentary with the one we now have in front of us. And I think that will be fruitful for academics and practitioners alike. So thanks for the opportunity to be here with this panel. It's been a great discussion, and I look forward to seeing future iterations of it.
So no direct comments on anything that's said on the panel. I very much appreciate the views of everyone. Let me just add a fun point maybe at the end. You want to read the most surprising comment of the entire updated commentary. It is Article 17. Just when you think you know the ICRC, read what they say about a prisoner of war who overrepresents his rank, and they will throw you for a loop. I'll leave it at there. Thanks to everyone. Fascinating panel event. Thank you, Mike.
Good.
Oh, and may I say Happy Veterans Day, an early Happy Veterans Day to all the veterans, and particularly you, Mike.
Thank you, Sean. And thank you, Cordula, Tess, Sean, for joining us today. As Sean mentioned, this is a vitally important topic, as we well know, as we begin to celebrate or remember Remembrance Day in Europe and Veterans Day here in the United States. These commentaries have very direct consequences on people's lives. And I commend each of our panelists for their thoughtful comments here. Sean, I look forward to reading Article 17 and seeing what's in there.
Check it out.
And also, as we end this, happy 245th birthday to the United States Marine Corps. So, hoorah to you guys. Thank you, everyone, for joining us, and good afternoon, and have a great day.